Hey guys, another quick legal update for you regarding the eligibility of a candidate to be included on the ballot for a condominium election. The legislature this year, effective July 1, changed the requirements or the eligibility to serve on the Hey guys, another quick legal update for you regarding the eligibility of a candidate to be included on the ballot for an election in a condominium association. The legislature, effective July 1, changed the ineligibility requirements to be included on a ballot from somebody who's 90 days delinquent in a monetary obligation to 90 days delinquent in an assessment. So what I mean is, as of last year, effective up until July 1, before that, if a candidate was 90 days delinquent in any monetary obligation owed to the association, they were ineligible to be included on the ballot. They changed monetary obligation to assessment. So now a candidate can be 90 days delinquent in owing a monetary obligation, meaning a fine or registration fee or something like that, and should still be included on the ballot. However, if they owe an assessment, then they can be disqualified or not included on the ballot. So make sure that disqualifying factor, you're aware of it this year and you're not disqualifying somebody who otherwise would have been eligible to serve. Even though last year they would have been disqualified, this year they're not. Now what the legislature didn't change was the use of monetary obligation when it comes to abandoning that seat on the board. So we still have the issue of if a director owes a monetary obligation to the association, they've abandoned their seat on the board. That's automatic, there's no asking for forgiveness or anything like that, that's just an automatic thing that happens. So we're in the situation, at least this year, perhaps they'll change it next year, is that if the candidate owes a monetary obligation, again, not an assessment, they own a monetary obligation to the association, they should be included on the ballot. Failure to include that candidate on the ballot would be grounds to redo the election. They should be included on the ballot. If they were to get elected though, they would immediately abandon their seat. So keep that in the back of your mind, but I also just want to make sure it's clear that this factor is now in place, and I'd hate to have an association disqualify a candidate for what would have been a valid reason last year, but is not a valid reason this year. Thanks, guys.